Hello friends. Welcome to Easy Studies. Do subscribe Easy Studies for more interesting videos. In this module we will learn about essentials of a valid contract. These 10 points are essentials of a valid contract. Do check out business law playlist guys. Offer and acceptance. Legal relationship. Lawful consideration. Capacity of parties. Free consent. Legality of object. Agreement not declared void. Terms of the agreement must be certain. Possibility of performance. Legal formalities. Firstly, a valid offer and acceptance. A contract is a valid contract only when there exists a valid offer and its valid acceptance. Proper communication of offer. Acceptance must be absolute and unconditional and also with prescribed mode and timely. 2. Intention to create legal relationship. The intention of parties to a valid contract must be to create legal relationship between them. In a social and domestic agreement, the intention of the parties is not to make it legally binding on them. 3. Lawful consideration. For a contract to be valid, the agreement between the parties must be backed by consideration. Consideration means something in return. Both the parties to the agreement must give and get something in return. Example: X agrees to sell his bike to Y for Rs 25,000 and Y promises to pay is the consideration for X's promise to sell the bike, and X's promise to sell is the consideration for Y's promise to pay. 4. Capacity of parties. The parties must be competent to contract, capable of entering into a valid contract. A person is capable of entering into a valid contract if he has attained the age of majority, is of sound mind and is not disqualified from contracting by any law to which he is subject. For example, A lends Rs 1,000 to B, a minor. A cannot take legal action against repayment, as an agreement with a minor is void. 5. Free consent. Consent means willingness. The consent of the parties to a valid contract must come freely. It must not be obtained by force or by suppressing facts. Consent is said to be free when it is obtained by coercion, undue influence, fraud. 6. Legality of object. The object of the agreement must not be illegal, immoral, or opposed to public policy. For example, X enters into an agreement with Y to supply certain prohibited goods. Such an agreement is void, as its object is illegal. 7. Agreement not declared void. The agreement between the parties must not have been declared void expressly by any law in force in the country. For example, under the Indian Contract Act, an agreement in restraint of marriage or an agreement in restraint of trade is void. 8. Terms of the agreement must be certain. The terms of the agreement must be clear, precise, and certain. If the terms are vague or ambiguous, the agreement cannot be enforced. 9. Possibility of performance. What is undertaken by the parties to an agreement must be such that it can be performed. An agreement to do an impossible act cannot be enforced. For example, X agrees to prove that two parallel line can meet if Y pays him Rs 10,000. Such an agreement is incapable of being carried out and is therefore void. 10. Legal formalities. For a contract to be enforceable in a court of law, it must comply with the necessary legal formalities as to writing, stamp duty, registration, certification, witness, etc. A contract will be valid contract only when all the essential elements mentioned above are present in it. Thank you for watching this video. Hope you learned the essentials of a valid contract. Do subscribe Easy Studies for educational videos. Bye.